Okay, Assalamualaikum warahmatullahi wabarakatuh. Hello everyone, I am David Prasetya. In this video, we will discuss about mood card with Fikri and Sando. Next slide.
Preparing to present your mood. The key to any good oral presentation is practice, practice, practice. And this is especially the case with mooting where the judge can and will ask you questions. The more you practice, the more you'll be comfortable with the unexpected, and the more comfortable you are, the more relaxed and perceived you'll be. Practice also always you to be flexible and to answer whatever the judge asks whenever they ask it. So here are some tips on how to practice first. You might want to write out what you want to say in full, which will allow you to order your argument in a logical way. It will also allow you to work out whether it's too long or too short. Be mindful when you're through that when you actually do the move. It has to be a conversation with the judge. You can have a fully written speech in front of you because when you're standing up in a mood and you're nervous, you'll be the best to read of it. And that is not what mooting is, putting the main points on a single piece of paper and then practicing from that. If you can record yourself doing this, so you can check whether you miss any arguments or any of the main points. But remember when you go to actually do the route, it's not the fully written speech you use, but this single piece of paper. Because mooting is not about reading of a script. You convince people by looking at them and talking to them.
So that as a single piece of paper with the main point on it when reading what you are going to say. As plain English, too many people think that mooting is about as complicated word or legal word. It's not. It's about having a conversation with the chat. And when you having a conversation with somebody, you don't ask legal word or talk in a complicated way to make sure that your argument are explained simply. Uh, Try practicing your oral submission to somebody who doesn't know anything about the mood or even about the law. If you can explain your argument to a reasonably intelligent person so they understand it, then you're not doing your job and allow this person to ask you question because that will help you work out where it is in your oral submission thing and explain it in a simple way but listen on and preferably many more times before you move. The result practice as if you were actually in the mood, dressing what you dressing what you're doing to wear, present in a formal environment. Time you speech and you have somebody act as the judge. Allow the person who acting as a judge to ask you question that you would better be able to anticipate what the mood judge will be asking her at Bond University when our students are preparing for a competition. They, prac- they practice literally dozens and dozens of times before they go off to complete.
Okay, everyone. In the next, we will give an example of the boot card. 2009 Jessup World Championship round. Good afternoon, President Sema and Judge Wedgwood and Alvarez. My name is Sebastian Machado, and it is an honor for me to appear before the International Court of Justice this afternoon. Pleading on behalf of the Republic of Alicanto, I will speak for the following 22 minutes, and I will be addressing Alicanto's firstly submissions. The first one referring to the contract to revision intervention in Alicantan territory and how it contravenes international law, and I will venture into the intelligence which was gathered to justify this operation. I will then yield the floor to my CEO again, Mr. Guillermo Turan, who will speak for 21 minutes, and he will address Alicanto's last two submissions. The third will referring to the conduct of revision troops while stationed at Camp Tara. And lastly, the assassin Ricardo Nati, and how he must be immediately delivered to Alicanto to comply with his judicial sentence. In consequence, Your Excellencies will be reserving 2 minutes for a rebuttal. Mr. President, and I may plead the court. In December 2005, the United Nations Security Council adopted Resolution 5440, but which it authorized a peacekeeping operation inside the territory of Alicante. Once this operation was complete, Your Excellencies, notwithstanding the allegation of the sexual exploitation and the broadcasting, subject the floor three submission, revision decided nonetheless to intervene, circumventing the fact, Your Excellencies, that the Security Council reject not once but twice an express proposal to intervene in Alicanto. One of the reasons to intervene, Your Excellencies, was the assassination of Alicanto's Prime Minister, Guek Lisamari. But the assassin is at this very moment of scanning at Camtara under the jurisdiction of the respondent state. It is your restless is the intervention in Alicanto territory after the adoption of Resolution 6620, which is of interest to the bench for our first submission. Your Excellencies, I will deal with two arguments in our first submission. The first one referring to legal effect of Resolution 6620. And I will then turn on to the more difficult question on this alleged rule of customary character which allow for a third say to intervene. When they consider that there is a humanitarian situation that so calls for this intervention, Your Excellencies, as to the S to out first round, Resolution 6620 is not an authorization for the use of force. It is not because a closer look at the practice of the Security Council will show that when the Security Council authorized Chapter 7 mission, it used three factors. I am reporting data by an intervening state of very clear scope of mandates and very precise language to authorize the mission. Your Excellencies, none of these factors are found in Resolution 6620.
Council, would you say that for instance, the authorization given to the coalition in 1990 resolution 678 is a good example of a clear mandate?
It is, Mr. President, for one reason, and I understand your concern, because Resolution 678 merely referred to the obligation set out in Resolution 6620. But it is in the sense that the mandate is very clear, that is to comply with the obligation to push Iraqi troops back into the state of Iraq. And there was a very clear language and a very precise mandate. Your Excellency, nonetheless, this resolution and of the operation in 1990 did include to the other factor, reporting duty by the intervening state and a very precise scope or language for the authorization they respond.
As the president, I think that was adverting 678 did have language which spoke us the restoration of religion, peace, and security. So the Security Council does know how to talk in the riddle if they want to. Doesn't you know that?
Your Excellency, I understand your concern, and Resolution 678 did not use express language, such as to authorize the use of force, but it did make reference to the issue of necessary, the use of all necessary measures, and this term necessary or the question of necessary has been consistent in Security Council resolution authorizing for the use of force. Ever since the first resolution which authorized the use of force, Resolution 83, 1950, against North Korea.
So I am a little puzzled in that where I'm neatly jumping to figure out the Security Council doing, which sound like where you're being asked. And I think this happens on the other side as well to second guess the Security Council. Why exactly other than the fact that you've agreed to be here? Does this card have correction at all? It would seem to be the case that this case is as the Security Council says, and that very same resolution says out the matter. Why are we size of it?
Your Excellency, that question was addressed by this court in the Tahiran Estates case, and in paragraph 40, it clearly states that when the council side of the matter in its political aspect, the court can very well be sized of the matter and in its legal aspect, and that is precisely what we put forward before the court. And it is also important to note, Judge Alvarez, that before the court, there have been examination on the legal effect to Security Council resolution, such as the Lockerbie contentious case by which the court had to analyze effect of council resolution as to determine its jurisdiction. Okay, thank you everyone for watching. Assalamualaikum warahmatullahi wabarakatuh.